Okay, perfect. So we're going to kick off. Good evening to all our IWFSA esteemed members joining us this evening. Thank you very much for taking time out of a very busy week and a very long day. I know for so many of us, it's just been such a hectic couple of weeks. But again, I think courtesy of our chair of the Development Committee, the Leadership and Development Committee, as well as the president of IWFSA, who are here on the platform with us, we thought it essential just to continue with this very vital conversation, because again, in the practice session, we were talking with two of our guest speakers tonight, and we were just reminding ourselves that this act is now going to be implemented in the next couple of weeks. We know that there have been various challenges around how many corporates and as individuals we have dealt with this act. And I was saying that personally, I know for my organization, I'm responsible for dragging my feet, and now suddenly I hear penalties come with the act, and now I'm sitting up and paying attention. So we thought that it's important for us to bring this conversation to the table. And we really and truly value your participation. It's what makes these conversations so exciting and so interesting. So welcome to all of our esteemed members who are joining us this evening. We also have the chair of our Leadership Development Committee, Ms. Futi Ntoba, who's joining us this evening. Thank you, Sis Futi, for actually taking time out of an also very hectic week to come through and also share some of the thoughts around why we're having this conversation. And of course, we have Madam Prayers.
Good evening.
Good evening, Sis Futi.
Good evening.
Zingle, I think, okay, we're having some feedback.
Yeah.
Maybe let's all go on mute. Maybe let's mute Sis Futi as well. Okay, we're all on mute. And then we also have the chair of, we have the president of the IWFSA, Ms. Irene Shanley, who's also joining us this evening. And before I actually introduce our speakers, let me hand over to Ms. Irene Shanley, who is our president of the International Women's Forum South Africa, who will just be sharing a bit more light on the protection of the Personal Information Act and why we're actually holding this conversation this evening. Over to you, Madam President.
Now, thank you so much, Charmaine, and good evening to everybody, our esteemed and beautiful members, and welcome to Varsha and Karen as well. And really, I'm actually quite excited about, this evening, because, I mean, all of us know that, and I mean, just a bit for Karen and Varsha, that you obviously know that the IWFSA is part of a global organization of about 7,000 esteemed women leaders represented across 36 countries in all 6 continents. And we are the South African chapter, of part of this global organization. And we have roughly about 100 women leaders. Our membership is, it's closed. And it's by invitation only, and then once you're invited, the board of IWFSA then approve our members, and then they pay some annual fees. And most of our membership are leaders. They, in fact, probably about 60% of our membership are at the board level, and the companies that they are, others are CEOs, or very key executives in various organizations, very large organizations across the sectors in our country. And therefore, I think the discussion tonight is very, very important, in terms of our membership base, and also other organizations that we work very close, other women's organizations that we also work very close with. So certainly, I mean, I think just to introduce the discussion, we all know, and I mean, both Futi and Charmaine just mentioned now, that in 2013, the Protection of Personal Information Act, we all call it POPIA was passed in Parliament. And, you know, the goal of the POPIA Act is to protect, you know, data, to protect information and data from any security breaches in companies, theft or discrimination, both in public and both the public and private companies and organizations and bodies need to be POPIA compliant by the 1st of July. So that's it's about 2 months away from now. And I think, as Charmaine was saying, that all of us are very, you know, everybody's waking up now, and it's quite important that we have to ensure that we're all compliant. What are the do's and the don'ts within this? So certainly, you know, the speakers that we have are the experts in this field, and both of the speakers tonight will unpack the POPIA Act, and they will explain how we need to ensure compliance, first of all, as the citizens of our country, members of IWFSA, you know, as leaders in many companies and organizations, you know, so it's quite important, and other leaders of organization, what we need to do, etc. So we do have obviously, as I've said, we've got 2 speakers. The first one, I think, is Vasha Sulal, and she's the executive for legal policy, etc., for the information regulator, and she will basically share some crucial elements of POPIA and the implementation date, the support that's required to ensure the success of the deployment within our organization of the Act. I think, and she'll be introduced further on. We also have Karen Wood, who's a partner at PwC Advisory, and she looking at the forensic, risk, and regulatory, and she obviously will share with us how businesses and organizations can ensure compliance and readiness, and various forms of legal support that's actually available to businesses and organizations to ensure the successful deployment. And then I think after that, there should be a question and answer session, which will be, I think, and the way we normally do it is in a conversational style, you know, and I think, you know, Charmaine will explain, we probably post our comments in the chat box, and then the closing remarks and reflections will be given by the chair of the IWFSA Leadership Committee, who will also be and so the chair of the IWFSA is Ms. Futi Mtoba. I think she's going to be the moderator as well of today's session. Between the 2 speakers, it's Futi or yourself, Charmaine, and then a key of the leadership committee and also responsible for YLC is Charmaine Hovey. I'm going to hand over now. I mean, I really look forward to today's session. In fact, I'm just trying to, you know what, I actually look forward to the session. I think it's going to be very, very informative and educational, and so I really look forward to that. I'm going to hand over to Futi Mtoba, who's the chair of the IWFSA Leadership Committee. She's also a board member of IWFSA. I don't know what happened there. And so Futi, over to you, and just to moderate, you are moderating the session. And thank you, Charmaine, for actually organizing this together with the YLC team, Zindler, this is fantastic, and I look forward to the discussion. Thank you.
Thank you very much, Madam President, and thank you for joining us this evening and always being there to support Thank you very members. Madam President, good evening. Thank you for joining us this evening. So on behalf of the Leadership Development Committee, I would like to welcome all of you, and also to add my own welcome to our esteemed panelists this evening, who our moderator for the evening, Charmaine, will introduce them in detail. Just from us as a leadership committee, these conversations are quite crucial, because as a voice of women in business, you need to know what you are talking about. So the first part of it is that it informs members so that we can talk with an authentic voice. The other part is that we believe in continuous learning. So we learn every day, and to lead, you also have to be on top of your game. So this helps us to sharpen us in what is going on. And then more importantly is that after these conversations, we also identify gaps in the market, and then we can then start our advocacy program. So that is basically how we see this. So without any further ado, Madam President has laid out thoroughly our expectation for the evening, and we are very excited to be here and to be educated. So I would hand over to Charmaine, who is also a member of the Leadership Development Committee. And that committee focuses on 4 pillars, which is self-development of our own members, and then development of the young people in the program that we call the IWFSA Leadership Development Program for younger generation, and then the YLC, which is the Young Leaders Connect, and then this conversation series so form part of that 4th pillar. So Charmaine, over to you, and thank you very much to you for always being there to support us, over and above that, your own organization, Cisco, for providing the platform. Thank you.
Thank you so much, Ms. Putim and Ms. Irene Shanley. So I'm going to jump straight in, and I think this series is very different to the ones that we normally host on a monthly basis. This is going to be a seminar type of series this evening, simply because of the detail of the content that's going to be presented to us. But as we normally do, speakers, as you're speaking, our members have the opportunity to post their Q&As, or just in the chat group, just to post comments, just to chat. And I will then just read to you, once you finish with your conversation, just what members are posting in the different chat groups. I'm going to jump straight into the first speaker. Thank you so much for joining us, Ms. Varsha Sulal, who was admitted as an attorney in 1998 and has practiced as an attorney specializing in drafting and civil litigation. Varsha is actually from my sector. She's an information communication technology law doctoral student, and she joined the Office of the Public Protector in my hometown, Durban, from 2001 to 2008. Varsha was appointed as Master of the High Court in January 2009, serving the Department of Justice and Constitutional Development for 9.5 years. And during her tenure as Master of the High Court, she was concurrently appointed as the project leader dealing with the transformation of state legal services, where she developed policies and guidelines on briefing of legal representation, the transformation of state legal services, and advanced the uptake of mediation by state institutions to mitigate excessive legal costs. She has actively promoted digitalization of state services to promote productivity, reduce administration costs, and ensure that services are citizen-centric. Varsha then took up the post of Master of the North Gauteng High Court, Pretoria, in 2016, heading the largest master's office in country. And she was later appointed as Chief Director of Legal Services, where she headed legal services for the Department of Labor, Workmen's Compensation, and the Unemployment Insurance Fund. Varsha is currently the Executive Officer heading Legal, Policy Research and Information Technology Analysis, and the Deputy Information Officer at the Information Regulator of South Africa. And again, we receive apologies from Advocate Pansy Tlakula, who was due to join us this evening and then had a last-minute emergency that she had to attend to. And she said if she manages to actually finish off, she'll still try her best just to listen in and join us. Varsha is engaged on both a national and international level in promoting internet governance, which I think is so crucial, especially across the continent, where we know we have issues where if there's an election or if there's anything happening, we see how leaders switch off the internet, which doesn't bode well just for us in terms of keeping connected and for connectivity. So in promoting internet governance and ICT policy development to influence inclusion and growth, a cause that is close to our heart, and she's a CyberBricks Associated Scholar. So actually quite an accomplished speaker this evening. And actually Varsha's qualifications are actually a page long and are actually very, very impressive. So thank you very much, Varsha. We truly, are honored to have you join us this evening. Thank you very, very much. And the next speaker before Varsha kicks off is Ms. Karen Woods, who's a partner in the forensic department in PwC, focusing on risk and regulation. Karen holds a BA LLB from the University of Witwatersrand and a master's in law, cum laude, specializing in banking law from the University of South Africa. She is an admitted advocate with extensive knowledge of both the legislative environment applicable to and practices adopted across regulated industries, with a specific focus on financial services and experience in the establishment and implementation of compliance policies, procedures, and frameworks across organizations and industries. Before joining PwC, Karen was responsible for regulatory compliance, including AMI, CFT, and sanction compliance across Southern Africa, so Angola, Botswana, Mauritius, South Africa, Zambia, and Zimbabwe at Standard Chartered Bank. And prior to that, she ran her own legal and compliance consultancy, specializing in regulatory compliance with a specific focus on the financial services industry. And Karen also has extensive experience in training, having held the position of head of the legal department at the University of Midrand and lectured in various LLB and legal diploma subjects. She's a self-starter who has a proven track record of managing and developing diverse teams. She is assertive, confident, diligent, and determined, and she is pragmatic and solutions-oriented with extensive experience in dealing with diverse stakeholders at various levels of an organization to facilitate solutions aligned to client expectations. So I'm going to hand over now to Ms. Varsha Sulal to just take us through the presentation. And once you are done with the presentation, we'll see if there's any Q&A for you, and then we'll swiftly move over to Karen. I see one of our members who's dialed in, Ms. Nikki Galatio. You're in very good company tonight because the legal fraternity, which you belong to, will be presenting. And Nikki, you will actually explain all of this to us once we're done with this call. So over to you, Ms. Sulal. Thank you very much.
Thank you so much, Charmaine. Good evening, Madam President, and esteemed guests, which I feel very honored to be here tonight to share my presentation with you, to share my thoughts, and to impart any bit of knowledge that is possible for me to do so. Empowerment of women is something that's particularly close to my heart, and it's the reason I started pursuing my doctoral studies, to ensure that women, particularly women in the ICT field, can receive further training and further development opportunities through ICTs. I'm going to go now through to my presentation, and okay. The Information Regulator was established in terms of Section 39 of the Protection of Personal Information Act 4 of 2013. And in terms of this section, the regulator is independent and is subject only to the Constitution and the law, and must exercise its powers without fear, favor, or prejudice. It exercises its powers and performs its functions in terms of the Protection of Personal Information Act and in terms of the Promotion of Access to Information Act. The regulator is one of the few globally that deals with both of these mandates. And the regulator is accountable to the National Assembly. The current members of the regulator took office on the 1st of December 2016, and their 5-year term will end in November 2021. So the term at the moment is, there are a few more months left for the term, and save for one member who was appointed on the 1st of December 2020 after the resignation of one part-time member. This 5-year period can also be extended if the National Assembly deems so. Now, to take you through some of the key definitions. A data subject makes reference to a person, a data subject relates to the subject of relates to a person whose personal information is being dealt with. So you would be a data subject. If you are an applicant for a bank loan, for instance, you would be a data subject, and the bank would serve as the responsible party. Personal information, it relates to an identifiable, living, natural person, and where applicable, an identifiable existing juristic person. Again, this piece of legislation is one of the few in the world that deals with both that protects the personal information of both natural and juristic persons. It includes, but not it includes, those not limited to, information that relates to race, gender, sex, pregnancy, marital status, national, ethnic, or social origin, color, sexual orientation, age, physical or mental health, your well-being, disability, religion, conscience, belief, culture, language, and birth of a person. As you can see, the definition of personal information is quite extensive, and one can appreciate how this type of information is required to be protected particularly now in the digital age, and how important it is for you to have an understanding of what information is actually recognized legally as being personal information. A private body is one who carries on or has, or who carries on a private business, a partnership, which carries or has carried on any trade, business, or profession, or any former or existing juristic person, which excludes a public body. Processing means any operation or activity or any set of operations, whether or not by automatic means, concerning personal information. There are further definitions in the Act, and these definitions I haven't gone through in this presentation, though it's worthy for you to have a look at, just for you to get a better understanding of the Act. The regulator's powers have been predetermined in terms of Section 40, and the mandate includes the provision of education to monitor and enforce compliance with the Protection of Personal Information Act, to consult with interested parties, handle complaints, and to conduct research and to report to Parliament. The regulator is also responsible for issuing guidance notes and a code of conduct, to make guidelines to assist bodies to develop or apply for codes of conduct, and to facilitate cross-border cooperation in the enforcement of privacy laws. The purpose of the Act is to give effect to the right to privacy by safeguarding, by ensuring that there are provisions which can safeguard your private information, and information that's processed by a responsible party must be subject to justifiable limitations. The limitations that are as follows, where you need to balance the right to privacy against other rights, particularly the right of access to information and protecting important interests like the free flow of information within the Republic and across international borders. Data has very much become a new type of currency, and its value knows unknown boundaries and has been proven to to build on the GDP of an economy. So in this point of the global economy, data is deemed to be some form of currency, and this is particularly why you find the world over data protection has become such a significant piece of legislation because it impacts significantly on the economy of the country. Further to this, the regulator is tasked with ensuring that personal information is processed responsibly and is also in harmony with international standards, ensuring that minimum thresholds for the lawful processing of personal information are observed. It's also important to ensure that people are provided with the rights and remedies to protect their personal information from processing that is not in line with the provisions of POPIA. And one of the, as I mentioned before, one of the fundamental roles of the information regulator is to create awareness. One from my advocacy days back in the day when I used to be with the Office of the Public Protector, I worked continuously on ensuring education on the Constitution. One is unable to protect your rights if you don't understand them, which is why advocacy is such a critical part of this piece of legislation. The regulator is also tasked with establishing voluntary and compulsory measures, which include the establishment of the regulator to ensure the respect for and promote and enforce and fulfill the rights protected by this Act. POPIA applies to the protection of personal information, and it also relates to ensuring protection of personal information when a responsible party is utilizing automated or non-automated means. And this, for instance, could very well deal with instances where your personal information is accessed by call centers, and this is quite a contentious issue at the moment, because more often than not, you would receive a call from a call center and you have not sanctioned the authority of the use of your personal information, nor have you sanctioned being contacted by these call centers. So POPIA is going to change this. This is why responsible parties have to ensure that they comply with the 8 conditions of lawful processing. POPIA in itself, in terms of Section 3, it takes precedence over other laws that regulates the processing of personal information and which would be deemed to be materially inconsistent with the provisions of POPIA. And I think this provision was included so that there would be some sort of material condition that will ensure the hierarchy, the precedence of POPIA being higher up in the hierarchy when dealing with other pieces of legislation which might have lesser forms of protection. POPIA applies to both public and private bodies. On the 1st of July 2021, we must ensure that all processing complies with POPIA, because this would be the effective date of the residual provisions of POPIA, and it's also when the enforcement powers of the regulator will come into effect. On the 30th of June 2021, the regulator will be responsible for the promotion for the promotion and enforcement and enforcement of the rights protected by the Promotion of Access to Information Act, this function is currently performed by the South African Human Rights Commission, and on the 30th of June 2021, the regulator will take control over this, over the protection of this right. On the 1st of July 2021, POPIA shall also become applicable to the processing of personal information referred to in Section 57 of POPIA. And these are instances where you would require prior authorization from the information regulator prior to you being able to process this information. The regulations in terms of Section 1122 of POPIA will come into operation as follows. Regulation 5 has already come into operation, and this deals with the application for issuing a code of conduct. This came into effect on the 1st of March 2021. Regulation 4, which deals with the responsibilities of information officers, and this again is an area that many corporate entities are interested in, because this regulation will come into effect on the 1st of May 2021. All residual regulations will come into effect on the 1st of July 2021. It's important, before you unpack this piece of legislation, that we understand who are the different role players within this piece of legislation. There are 3 critical role players. One is there are 4 critical role players, but I would say there are mostly 3 critical role players when you try to understand this piece of legislation. The data subject is the person to whom the personal information relates, and the responsible party would be the person which determines the purpose of or the means of processing that personal information. I gave you the example before of an applicant for a loan at a banking institute. That applicant would be the data subject, and the responsible party, which will have to determine the purpose and the means for processing, would be the banking or the credit facility. An operator.
Walter, sorry, can I just check? I think your presentation is not moving. I think you're on slide 16 now.
Oh, is it not? Oh my goodness. I'm sorry.
And I think it's still showing slide 9.
Oh my goodness. Is that better?
Yeah, there you go. Yeah.
Oh goodness. I think there is a. I must apologize for that. I don't know how that happened.
So there you go. Now you're back on track.
Okay, perfect. Thank you. So an operator is a person who processes personal information for a responsible party in terms of a contract or mandate, and this entity does not come under the direct authority of that party. And I'm going to just explain how important it is for a responsible party to enter into an operator agreement. Because you might often find that there would be instances where an entity will contract an operator to assist it with some of its processing activities. The implications of POPIA are such that should there be a breach, or should the operator not safeguard the personal information, the responsible party would be liable in terms of POPIA. Which is why, if you are looking at safeguarding the liability of a responsible party, why it is critical for a responsible party to enter into an operator agreement with any person who processes personal information for the responsible party, and to ensure that there are adequate safeguards enclosed in that contract. A competent person would be any person who is legally competent to consent to any action or decision being taken in respect of a matter concerning a child. There are provisions in POPIA which deal with the protection of personal information of children, and this is why a competent person would be one of the significant role players when trying to unpack this piece of legislation. There are 8 conditions to the lawful processing of personal information, and these 8 conditions are accountability, processing limitation, purpose specification, further processing limitation, information quality, openness, security safeguards, and data subject participation. I'm going to give you a little more information on what this deals with. Accountability is one of the conditions that requires you to ensure there's compliance with lawful processing. Processing limitation deals with personal information which must be processed lawfully in a reasonable manner that does not infringe on the privacy of a data subject. The principle of minimality basically deals with whether or not the information that you are obtaining or securing, is it adequate? Is it relevant? Are you securing more information than you actually need? And is that information excessive? For instance, if I sign into a building and the building requires that I give them my full name, my physical address, my identity number, my car registration details, and my cell phone number. Now, my identity number, my car registration details might be relevant because of security purposes and I might be parking in the building, but my identity number is not relevant. My address is not relevant. My cell phone number and my name might be relevant, but anything over and above that would be considered excessive. And which is why processing limitation, you often find that we are in a culture where excessive information is collected and you're not certain what happens to that information, how that information is stored, and whether or not that information can be compromised at any given time. In addition to processing limitation, it's essential that you secure consent. There's justification for securing this information, and should there be an objection to dealing with that information, that objection is dealt with adequately, and collection of personal information must be directly from the data subject. Purpose specification, it relates to the fact that you need to collect personal information for a specific purpose. And retention and restriction of records must not be retained for a period longer than for the initial purpose. For instance, if you collect personal information to perform a function, and then further down the line, you decide that you need to utilize this information for the insurance subsidiary of your company, and you're not entitled to do so because you have to secure the consent of the data subject. If you have collected personal information for a specific purpose and further down the line you decide that you want to utilize this information for a purpose that it does not relate to the initial purpose of collection. And records cannot be retained for a period longer than for that initial purpose. And this is you will find that both public and private entities collect information and retain information for decades. And this information, more often than not, is also not stored in a safe environment, and can often be prone to breach. And
so on
once
that point,
POPIA
Barsha,
comes
so maybe just on that point, once POPIA actually becomes the rule of law from the 1st of July, will it still be legal for housing estates to scan driver's licenses that have all your personal information? Especially since, to your point, we don't know how it's scanned, and if it's scanned in a legal manner, will that still be permissible?
I don't believe it's going to be permissible. You know, I think unless you give them consent,
Okay.
they need to also, or if they're going to scan it, it has to be for, as I said, you know, it has to be for a specific purpose. If they say it's to ensure the security of the estate that you want to enter into, and the condition of you entering that estate is for you to consent to your driver's license being scanned. Once you render that consent, then you have appreciated that, you know, your information has now been handed over. But it will be incumbent on that particular estate to destroy those records after the purpose of that collection has now subsided. If there has been no criminal activity, or they can't justify the retention of those records, I can't understand why they would keep those records for a long
And
period.
again, right, I think a point being made by somebody is that with the reason why we give the licenses voluntarily is because we will be refused entry. Because to your point, the condition of entry is one of safety. And then again, how do we know once we exit that our data has been removed? And how do we check that indeed our data has been removed?
I think estates all over the country have been doing this without data subjects fully appreciating what happens to their information and how that information is stored, and so it's going to become very problematic. They need to justify what is a basis for them to scan your driver's license.
And I guess they also going to become, because they now also become subjects who are now responsible for adopting POPIA, right?
Yeah.
And I guess if a complaint is made to the information regulator about a certain state, then the information regulator is able to take up that case.
No, absolutely. But remember, you know, we're talking about now the 8 conditions for lawful processing.
Yes.
So,
Yes.
so responsible parties are going to have to ensure that they are complying with these 8 conditions. That means they need to make sure that they obtain the requisite consent, that they employ the adequate safeguards, that there are processing limitations to how they utilize this information. The information must be purpose specific, you know, and the thing is with estates, they can't say that it's for it's not a legal requirement. It's not for historical purposes. There's no statistical purpose that it's going to. There's no statistical or research purpose that it will attain by them securing the information. So you can't. There will be little justification for it. And what has to happen is that after they have utilized that information for that particular purpose, they will have to destroy or de-identify that record. Even if you're dealing with the issue with an estate, if you're getting entry, there has to be you need to be aware as to how long they're going to keep that information, and whether or not they're going to de-identify and destroy it, and how are they going to actually inform you of that. So these mechanisms have to be in place.
Got it. Okay, I'm just giving you a 10-minute checklist. Just to know, you've got 10 more minutes. We've got like reams and reams of questions here for you as well.
Oh my goodness. Okay, I'm going to scoot through this presentation then, because I mean, but I think the fundamental understanding of the Act rests on these 8 conditions of lawful processing. The others are further processing limitation, and I spoke about that as well. That you need to secure consent if you're going to utilize the information for an additional purpose. You need to ensure information quality. So personal information must be complete, it must be accurate, it must not be misleading, and it must be updated. The other condition is openness. So responsible parties must maintain records, and they must notify a data subject when collecting personal information. The other 2 are security safeguards, and it's critical that security measures are adopted by all responsible parties and operators. Data subject participation. A data subject, as you know, the example that you gave me now of an estate, A data subject must have access to that personal information, and they must be able to correct or delete that personal information if it's inaccurate. And again, we speak about, has the purpose of the collection been achieved, and is it necessary to retain that information any longer? And I did mention that all public and private bodies must ensure that there's compliance with the 8 conditions of lawful processing. I'm going to now go on to the duties and responsibilities of information officers. It is essential that an information officer is appointed. And part of this, the information regulator has published a guideline on registration of information officers, and they would deal with requests made to the body pursuant to POPIA, but subsequent to POPIA coming into full force in effect, information officers are now dealt with by both POPIA and POPIA. And an information officer will have to ensure registration with the information regulator. The information regulator, just to give you an update, is currently working on an online registration system to ensure that all information officers and deputy information officers are registered. I just want to quickly go through trans-border information flows. This is dealt with in terms of Section 72 of POPIA, and this basically stipulates that a responsible party cannot transfer personal information about a data subject to a third party in a foreign country unless third party who will be receiving that information is subject to a law, binding corporate rules, or a binding agreement which renders an adequate level of protection. And I think what has happened now in this time is that borders have become seamless, and information flows are quite progressive, and you don't find limitations to how information is shared. Particularly with cloud sharing and cloud computing, you find that your information could be stored in any host of countries, and you don't know for certain whether or not you'll be receiving the same level of protection that POPIA will render to you, which is why compliance with Section 72 is so critical. I'm just going to quickly go through the enforcement powers of the regulator. So the regulator has the power to enforce. There are enforcement mechanisms in POPIA to ensure that should there be a breach of POPIA, then there would be adequate penalties and sanctions which would emanate from that breach. Responsible parties or data subjects have the power to submit a complaint to the regulator, and if they're aggrieved by the determination of the regulator, if they're aggrieved by that decision, an adjudicator can be appointed relating to that particular complaint. I'm also going to I'm going to quickly go through the investigative powers of the regulator. So the regulator has the power to summon and enforce the appearance of persons, administer oaths. The regulator is also empowered to enter, search any premises occupied by a responsible party after they obtain a warrant. And search and seizure with a warrant is also one of the powers that the regulator has, relating to any record or any piece of equipment that was used when processing personal information. The regulator is in the process of appointing the enforcement committee. So the enforcement committee would in all probability be chaired by a retired judge, and there would be expert members which would be appointed to the enforcement committee, and they will deal with complaints once the regulator has investigated a complaint. They will refer the matter to the enforcement committee, and the enforcement committee is empowered to adjudicate on further action to be taken in that matter. The enforcement committee is independent and will have to act impartially. So I'm going to, I think I might have just about 4 or 5 minutes left. I think what I'm going to quickly advise you of, and this presentation will be shared. There are numerous offenses and penalties. For instance, the information regulator can issue a fine or imprisonment for a period not exceeding 10 years, or both a fine and imprisonment, and the maximum fine that can be imposed by the regulator is 10 million. You'll find with numerous global breaches that quite hefty fines are being levied by these regulators, and this would have to be consistent with the nature of the breach and the damage suffered by data subjects. I'm going to quickly now go through the fines. Is something that you can easily access through the presentation. But what I would like to leave you with in conclusion is that data protection, or the protection of personal information, has become a critical facet of any economy, and it's also a critical facet of how will you conduct your business operations. And I think what will be necessary for all business entities to prepare is some sort of compliance checklist to ensure that there's compliance with POPIA. And my advice is to look at the 8 conditions of processing. Look at the processing activities that you undertake as an entity, and ensure that as far as possible, for every instance that you are processing personal information, whether it is for your clients or for your staff, that you try to observe as far as possible the 8 conditions of processing personal information, to ensure that your business begins conducting its activities in a responsible and conscientious manner. I think that the protection of personal information is more than just a piece of legislation, because behind that personal information are human beings, are people, and contravention of that information, if you do not adopt adequate security safeguards, it's commonplace now for people's personal information, their dates of birth, their banking details, to be exposed on websites after breaches. And I think we shouldn't be in a position where you're going to be reacting on a knee-jerk, occasion. Ensure that you prepare. Try to get as much advice as you possibly can about securing your systems. There are simple mechanisms that you can adopt internally in your corporate entities, just to ensure that you adopt security safeguards. For instance, something as simple as passwords. Make sure you have a policy that you implement internally on using on accessing the internet and accessing your records in the most safe and secure manner possible. Thank you very much. I appreciate the time that you've given me, and I'm open for all questions.
Thank you so much, Varsha. Thank you very much. So I think you mentioned a very important point just around the warrants. So a question asked is, can the regulator issue a warrant if a person summoned fails to appear?
Yes, a warrant will be issued by a magistrate. The regulator itself will not issue the warrant, but the warrant will be issued by a magistrate.
And a very vital question asked. So during lockdown, there was a big issue around Experian, alleged to have been selling people's data. Retrospectively, can we go back to that issue and hold them accountable? Or has the horse already bolted? Or how did that issue have been dealt with if the information regulator had already been in office and implemented?
I think, I think it's a difficult one to really hazard an opinion on, because at that time the enforcement powers of the regulator hadn't come into full force and effect. All I can say is that coming, from the 1st of July, they would, these types of breaches would be looked at in a different, will be cast with a different glance. And the regulator will be empowered to act more stringently. And I think it's something that we need to be very mindful of, because over and above, even if the regulator lacked any powers at that time, if a data subject found that they experienced some sort of financial damage or pecuniary damage arising out of that, let's just say Experian, nothing prevents them from instituting a civil claim, because any person still has access to the courts, whether or not the full matter of POPIA has come into force. There are other legal options. Obviously, you would have to be able to prove that, to prove your case, but there are options, there are civil remedies that are available to data subjects.
And then NGOs, I guess the question is, are they subject to POPIA? All of us are, right? Even in our personal capacities.
Yes. Everybody, yeah, private and public bodies, and that would cover NGOs would all be. And I think, I think for me, when I look at data protection, I think of it as an ethos. If you want to, you must have, you will adopt good governance processes. So data protection is in line with good governance controls. Yeah. You want to ensure that your business, your entity, whether you're a profit, a non-profit organization or not, you want to ensure that there's credibility, and that you conduct yourself with the highest level of ethics. And for me, it's more than just compliance with a piece of legislation, but it's about respecting your clients, respecting your employees, and respecting the way in which you conduct your business.
Spot on. And again, a question is there a POPIA handbook at this stage in all languages, in all official South African languages yet?
We don't have a handbook as yet, but what we do have is we've got guidelines to facilitate understanding of certain critical aspects of the Act. For instance, like how do you register an information officer? How would you develop a code of conduct? We've got a guideline on prior authorization. We will be developing guidelines on special personal information, information of children. How do you protect the information of children? Because children are more and more operating in a digital environment. We need to make sure that their rights and their information is protected. They become vulnerable to trafficking and a whole host of other cyberbullying and it's innumerable vulnerabilities that children are exposed to. So it's critical. It's critical work of the regulator to try and ensure that there's guidelines on this as well. Together with, we're also looking at cybersecurity guidelines. How will you protect your information? How will you make sure? And we will be looking at also developing a guideline on direct marketing. So this is the work that's still to unfold, and there's quite a lot. Watch the space, because there's a lot of work that's still in progress and that will be released shortly.
Thank you. And then a very important point being made, especially around our most critical resource that we worry about as IWFSA, is that there's so many young women, to your point, there's so many young women and entrepreneurs who are running around trying to kickstart their businesses, but they're not aware that there's this act out there called POPIA. And the question is, what activities are there to create this awareness and education? And are there opportunities for the information regulator to actually work with IWFSA and the YLC and the various other bodies that we actually run to ensure that we can actually run these education and awareness sessions just to prepare these women that we're coaching and mentoring to ensure that they are well prepared?
We have a communication and awareness directorate. We're in the process of filling more vacancies. We've just advertised. We have about 46 vacancies. At present, we're pretty thin when it comes to resources and staff capacity, but we're in the process of we've advertised these posts. And what we are doing is that all you need to do is email the regulator, request some sort of intervention in terms or assistance in terms of the awareness programs that you want to run. And I think because we have such scarce resources, if you can pull together as many attendees as possible, we can do one session, share information on the Act, just basic things, and to help young women and empower them in preparing themselves for the 1st of July.
And I know for a fact that even I've spoken to a number of associations, the American Chamber, etc., and the information regulator has been quite forthcoming in terms of meeting with different associations, meeting and sharing this information. So I think even with your limited resources, you have been quite agile in terms of supporting. And then a comment from somebody saying Home Affairs should police how the information they provide to external parties without our permission is actually used. And I guess, again, to your earlier point with the Experian and with the call centers and everybody who's selling this information, once the information regulator is now official with effect on the 1st of July, I guess maybe some of that caution from security agencies, from complexes and estates and everybody else, that light will suddenly be shone on them. And I think in these instances, all you need to do, as in GDPR that has been implemented in Europe, is make an example of one organization, and we very quickly start to sit up and pay attention.
Absolutely. I think what has happened in the EU, and I'm happy to say that I'm sure it's going to happen here, is that there will be a greater culture of compliance. And I mean, that culture of compliance that was achieved in the EU is primarily because of the hefty fines that have been levied, and I'm sure many entities don't want to be the one that they were made an example of, but that's sure to come. And come the 1st of July, where you feel that there's been a breach of your personal information, then complaints have to be levied as well. You need to lodge a complaint for the information regulator to assess whether or not you have a legitimate complaint. Have you raised it with the responsible party? What was the outcome of that? Are you satisfied? If you're not, you have recourse to the information regulator.
Brilliant. And Karen, over to you. As an organization, I know something that has kept us awake in Europe is ensuring that we're not part of the statistic in terms of GDPR. And again, even in my personal capacity, I'm always so petrified. If somebody says, do you have a contact number for Karen? I'm like, actually, no, I don't, even though I do, because again, I have that GDPR and the penalties and that in the back of my mind, and just the general respect, I think, that we will be taught as corporates and individuals now that we know that there is this law that is now sitting at the back of us. It's not going to be that easy to share information. Talk to us about some of the challenges that corporates and citizens have been experiencing just in terms of trying to ensure compliance, and maybe talk to us as well about some of the tools that are available for many of us who are panicking about this and thinking, especially like you saw the comment around small businesses, women-owned businesses. How do we ensure compliance? How do we ensure that we are not that number or that example? Over to you, Karen.
Thank you, Charmaine. And I'm not going to use my presentation, but I'll just touch on a couple of things. So I think we have touched on a few of them during the course of our conversation. But I think the first thing that I would say is that most of our clients, and it could be going back to the concept of education and being aware of the Act and the extent of the Act, don't quite know where to start. They, in their personal capacities, live in an environment where they pretty openly share data on a day-to-day basis. And I'm sure everybody on this call will agree that it's become almost a matter of course for us on a daily basis to share personal information without really giving too much of a second thought of that. But that is going to change. When you're looking at it from the corporate side, the question becomes, am I actually processing data? And is that data personal information? And I think that is an important place for all organizations to start, is asking that first question. Am I processing data? And when you're talking about processing data, you need to take a wide definition of what processing means, and people have to understand what processing means. And it is broad. It includes anything from collection, receipt, recording, collation, storage, updating, modification, retrieval, alteration, etc. So it's a very broad definition. And as part of our day-to-day, most organizations will process data. So that's the first realization that they have to come to. The second realization is then to say, what is the nature of that data? Is it personal information or special personal information? And Varsha highlighted the types of information that we are talking about. And when you think about it and think about those categories of data, bear in mind, once again, like Varsha said, it's not just information regarding individuals, but it is also information regarding corporate. And when you start unpacking the data which yourselves as an organization is processing, you'll realize that it's actually a lot more extensive in most cases than you think. Let me give you a couple of examples. If you have a human resources or human capital department, they are going to be collecting information about all your employees, whether that's their name, ID number, address, tax numbers, etc. But also they're going to be potentially collecting information for additional parties to that employee. For example, their children's names, their children's ID numbers, for the purposes of allocating that information for things like beneficiaries on policies, etc. Their husband from an emergency contact perspective, their past information around their prior employment for purposes of keeping a record of where they came from, what their experiences were. So HR would be a key department or business unit that does process data and processes information of a personal nature and potentially also personal special information, including children's information. Similarly, in your finance department, for example, or your procurement department, you will have a number of instances where the data of juristic persons is being collected, whether that's the name, the registered name of the entity, their physical address, their SIPC registration number, their VAT number for purposes of invoicing, etc. Now, when you start doing that analysis, it becomes quite clear that the extent of data that is being collected that is of a personal nature within most organizations, regardless of their level, is probably more extensive than people initially think. And that's why it's so important to start there, in my experience. Not just to assume that you have a decent knowledge of what data you're collecting, but to do the actual analysis. And within each of those business units, in relation to each of those processes, that you start mapping your data, the nature of the data, and the way in which it is collected, where it is kept, how it is processed, who it is shared with, etc. Now, that is quite an extensive exercise. And I think one of the challenges that our clients have had is just understanding that wealth of information and being able to take the time to map it. But that process is essential for a number of reasons, which I'll touch on just now. It is going to be pivotal to ensuring that you have the right level of governance and understanding of your data in order to meet all the conditions for the processing of that data, which Varsha alluded to. Let me give you a couple of examples. The first thing is, am I operating am I performing my function in processing that information as an operator or responsible party? Varsha touched on that. That is key. Remember, a responsible party is somebody who determines the purpose for which that data is being collected and the means by which it is processed, versus an operator who is essentially a third party who, in terms of a contract or a mandate, processes that information for you. Now, in most organizations, you're going to have both of those roles playing a role, in particular in your larger organizations. By way of an example, if you work in a banking or insurance environment, or even an asset manager environment, you're going to have people that are collecting that information for you in a third-party capacity, such as a fund administrator, for example, and they would then potentially be operating as either an operator or a responsible party. But determining those roles and responsibilities are key, as Varsha said, because it's going to define what your roles and responsibilities are in relation to that data, number one, and where you are potentially at risk, number two, through the use of a third party or an operator in relation to that data. Remember, as soon as you have additional parties having access to that personal information, you extend the scope of the processing of that data and the people that have got access to it. And as soon as you have more people with access to that data, you potentially have a greater risk of breach of that data. So it becomes very important from Varsha, as Varsha highlighted, that when you have operators, that you have the necessary contractual arrangement, operator agreements in place to make sure that you are adequately addressing those risks of that third party having access to that information and how they manage it. If they're going to be utilizing or storing that data on their own systems, how do you manage it? How do you manage that, the assurance around it? Do you need to go in and check how they are applying their own POPIA levels of compliance? Do you do service level agreements with them? Do you go in and do audits of them to make sure that you are having the right level of assurance as the responsible party, that they are managing your information or the data subject's information more clearly in a way that is aligned with your responsibilities as a responsible party, and once again, as we mentioned, in line with the culture that you bring towards the management of PI. Couple of other things. Do you understand not only what data you're collecting, but where is it? Where is it being stored? Where is it being used? Who is it being shared with? Which systems is it kept on? Or is it kept in physical form? And I think the one challenge that a lot of our clients are having is this concept of data only being electronic data as opposed to also physical data, and they seem to be often leaving the physical data as a consideration and not adequately applying their minds to the physical data, because that's something that they've been dealing with years, and they've got Metrofile that has it, but they're not looking at the physical and the electronic or the structured and unstructured data when they are doing their assessments. So defining the type of data that you are collecting and how it is being collected and how it is being stored is essential in that analysis, because that'll also help you define what the security mechanisms are which need to be in place in order to adequately secure that data. Now, interestingly, around security of data, a lot of our clients come to us and say, well, just tell us what we have to do. Give us a system that is secure. Give us a solution that is secure. And it's not necessarily as easy as that. There's not necessarily a one-size-fits-all solution, number one. And number two, obviously, technology solutions often come with a price tag. And as we mentioned earlier, some small organizations might not be able to meet the price tag attached to some security mechanisms on that data. Now, obviously, you can't avoid your obligations around that data and the need to make sure that it is secure. But how you do that is really going to come down to how well you understand your organization and how well you can put in place whether manual or electronic security controls in relation to it. And it can be something very simple or something very complex. I think a lot of our clients miss the point around simplicity at times. So for example, if you have shared drives, sorry, my lights are going off. If you have shared drives, and on those shared drives, you have data that is of a PI nature that is stored on that shared drive, how are you making sure that access to that shared drive is only given to those people that require access to that PI, and that they only access that PI for the purpose of which it was specifically collected? Okay, so if you're in the procurement department, or let's say the finance department, and you have copies of invoices, how do you limit the fact that only those people that are involved in ensuring the invoicing and payment of those invoices have that access? And that can be simply controlled through access control to those particular drives by removing people's access to that. It doesn't have to go any further than that if you do that appropriately. But once again, you have to understand what is the information that you are holding, why are you holding it, and where are you holding it in order to put those controls in place. And that is what we're finding that clients are really, really struggling with, is just doing that mapping in the first place. Varsha touched on, also in relation to data flows, Varsha did touch on the fact that often you have data that is actually transferring to third parties, and she spoke about cloudification. Often in large organizations, we've seen a lot more use of cloud technology to store data, but there's not a real good understanding of where that data is being stored. Where does it exist? Is there any cross-border implications in relation to that, which we need to take into account to make sure that it is as adequately secured, that it's subject to similar laws in the country in which it is stored? A lot of multinational organizations will have centralized data systems or warehouses where they will store information offshore. All those things need to be mapped in order for you to understand where you are storing that information, where you are sharing that information with other associated parties within your organization or third parties, and where it is possibly going cross-border, so you can make sure that the necessary arrangements are in place to manage the risk associated with that. Another challenge for our clients is defining this purpose specification and the legal basis for the processing. So a lot of our clients have been collecting information extensively over a number of years, and for example, they'll have an application form that has a whole bunch of information that is collected from the client, but they as a matter of course are doing that. We spoke about security at complexes. As a matter of course, those security officers are told to fill in or collect certain information. But there's been inadequate application of the mind by clients around why are we collecting it? What is the purpose for collecting it? Is it necessary for that particular purpose? For example, is it necessary for you to collect my medical data in relation to a situation where you want to employ me as an employee? Is it necessary for you to understand my marital status in order for me to be admitted to hospital? Okay, so the purpose specification, the purpose for which you are collecting that data, is another requirement that is important for you to map. So this is the type of data we are collecting and processing. Here is the definition of what that data is. Is it the name of the person, the ID of the person? Is it their residential address, etc.? And then the analysis of, do we need to collect that information, and is that information in line with the purpose for which we are collecting it? Does it serve the purpose for which we are collecting that information? If not, we shouldn't be collecting it. We should only be collecting what is minimally required in order for us to achieve the purpose for which we are collecting that information. And likewise, is there a legal basis for us to be processing that information? There's a number of pieces of legislation which obviously give you a basis upon which to collect and process information, or even legal or contractual obligations which legitimize the basis for you collecting that, or there might be consent in place. But doing that analysis to say, for example, if I'm a bank, that I'm collecting an individual's ID, because from a legislative perspective, based on my risk-based approach to collecting information to manage money laundering, it is a legislative requirement, and therefore I am allowed to collect it. So therefore my purpose is aligned to my legal basis, and I can collect that information. But that analysis has to be done. Another challenge that our clients are having is making sure their data is up to date, accurate, reliable, and complete. Now, historically, a lot of the large organizations have collected data for a considerable period of time, obviously, and they've collected that data on numerous systems. And unfortunately, what has happened is through the evolution of those systems or the introduction of new systems, they haven't necessarily ensured that there is consistency across systems around the accuracy of that data, number one, or made sure that there is one version of the truth in relation to that person, or made sure that that data which they have collected and have been keeping remains up to date. And that is proving to be a significant challenge for our clients in terms of doing that analysis, making sure that data is up to date, and then correcting that data when it isn't up to date, and then also if it's no longer needed, as Varsha said, de-identifying or destroying that information, because there's no reason for them to actually continue to retain it. And I think the the push and pull in a lot of those situations is that we're hearing from clients is, but there's value in that data. We can use that data for things like mining new opportunities or taking new products to our client. We want to keep it. Okay? And balancing that against the rights of the data subject to not have that data retained by you without your consent. And also bearing in mind that consent can be changed or withdrawn at certain periods or at any time during the time when you have that data. And unless you have a purpose or legal basis for retaining that you're going to have to destroy it. Okay. What do I do once I've got this in place? So once I've defined what data I'm processing, the nature of that data, where it is kept, where it is being used, where is it being flown between different systems or cross countries, do I have an understanding as to why I'm collecting that data? Have I documented the legal basis or purpose for which I am collecting that data? Now, how do I start to actually make sure that I'm putting in place policies, procedures, frameworks, systems to ensure ongoing compliance with the requirements? Now, once again, I think the challenge that we see with a number of clients is, okay, come and tell us how to do it, but give us a solution in a box. Give us something that'll do this all for us, okay? And I think what they're having to come to terms with is there isn't one size fits all approach. POPIA is very principles-based, very much like a lot of legislation these days, and you have to understand your own organization and understand the best way to manage the risks associated with your organization and the data that you're collecting in order to put in place policies and procedures and systems that are fit for purpose. You also have to understand your strategic intent long-term. You also have to understand your cost associated with putting in place things like complex systems and whether there are alternatives to put in place manual solutions and the associated risk in following a manual solution as opposed to a systemic solution. Now, a lot of organizations have got some of these aspects in place. So Barsha mentioned PIA, and a lot of organizations will have some structures in place from a PIA perspective, which they can leverage off. So organizations will often have IT security requirements which are in place. They will have data retention requirements or policies in place. And often the process that we advise clients to follow once they have mapped their data and done their data assessments is to now go and look at what you have got in place and see how you can best use what you already have in place in order to meet the requirements of POPIA. You don't have to start from scratch necessarily. We often find with organizations that are multinational, for example, that have other countries that are, or other subsidiaries or associates that are subject to things like GDPR will have good policies and procedures in place that can be adjusted to POPIA's requirements, bearing in mind that it's got a slightly different scope of application and includes heuristics, but they can leverage off those. Similarly, even smaller organizations that have, like I say, a POPIA, for example, a process around requesting information or managing a complaint in relation to requests in terms of POPIA, can take that existing policy procedure and simply enhance it to meet the requirements of POPIA instead of starting from scratch. But what is important is to do that gap analysis, because it's only once you do that gap analysis and you've finished your data analysis and mapping that you understand where you are in that journey, where you are potentially meeting the requirements or could meet the requirements through what we call quick wins by making changes to an existing policy or procedure, and where you have a lot more work to do. And it's that assessment which allows you to then develop a roadmap or an action plan to say, based on our data, analysis of the data that we process, based on our detailed understanding that we have gained around the nature of that information and the purpose for which we collect it, where it is stored, etc., we now know where our risks lie and where those risks are higher or lower, and through the gap assessment, where we don't have policies, procedures, processes in place to meet the requirements. And you can take those two together and you can use that as a basis to prioritize where to start. Now, before we kicked off the session, there was a lot of talk around organizations saying they haven't started. Where do you start? I've touched on a couple of things that you can do as a starting point, but please bear in mind that you've got to start somewhere. And what is important is understanding your risks as an individual organization and then mapping where those risks are higher or lower, and then starting with the higher risks as a focus area from an implementation perspective. And in doing that, you are going to achieve a much better blanket of your higher risks as opposed to trying to do everything at once. Okay. Now, I'm not for one moment advocating that you don't comply with any of the requirements or certain requirements of POPIA. And it is a question that we get asked quite often. The question is always, well, how do I ensure minimal compliance with POPIA? Okay, and that's definitely not what we're advocating. What we are advocating is that you cover the big risks first, because that is where there are significant risks to your data subject. And your culture should be supporting, and the requirements of POPIA are supporting you protecting that data subject and the information. So if you're going to take a risk-based approach and focus on the high-risk areas where you are potentially exposing data subjects, you're going to be adding that protection. But like any level of compliance to any piece of legislation, it's a continuum, it's a maturity, it's a road and a journey. So whilst we do not advocate or think that there is any concept of minimal compliance, you have to start somewhere, and that analysis will be key in order for you to decide where to take potentially limited resources in an environment where you potentially at this point in time have limited time to now focus on those bigger areas and then move to the less risky areas as a secondary step. And if you do that appropriately and you do that on a risk-based approach, you are going to be able to reach compliance within a relatively short period of time, and then over time build on the maturity level of compliance over time. We touched on earlier around culture of compliance, and I think it is very important what Varsha highlighted is compliance with POPIA is not just about a tick box approach. It's not just about going, okay, put that policy in place, put that procedure in place. If you don't have the right culture in your organization in relation to the management of personal data or PI, putting those policies and procedures in place is going to be completely ineffective, because nobody will be committed to implementing. Nobody will have the right mindset when they are on a day-to-day basis managing, processing personal information to ensure that you as an organization are meeting your requirements. So don't just think adequacy, think effectiveness, think culture to support that effectiveness on your journey as you move towards heightening compliance. The other thing that I would stress is that when we speak to a number of our colleagues in a number of other countries, which are a little bit further down the line when it comes to data privacy compliance, even those colleagues in the EU who have been dealing with GDPR for some time, the feedback that we are getting is there isn't 100% compliance in all their clients, that their clients continue to be on the journey, that the clients are continuing to improve the way and their level of understanding of the data that they have, that they deal with, that they process, where it's kept, and a greater understanding, unfortunately often through breaches or failures, as to where they can then go back to their policies and procedures or their security measures or their contractual arrangements to, on an ongoing basis, improve the maturity of their data privacy. So don't for 1 second think that July is going to come, you're going to be fully compliant, and that's going to be the end of it. This is going to be an ongoing journey as you go forward. And you are going to have to ensure not just compliance in July, but you're going to have to ensure compliance on an ongoing basis, each and every day, each and every month, each and every year. And you're going to have to provide assurance to your board, your senior management around that level of compliance. 2 other things that I'll touch on, Charmaine, if you'll allow me to, is number 1, who should be responsible for POPIA compliance? Who should be your information officer? It's always a challenge with our clients. The natural default in most of our clients is to say it should be someone in the IT environment, because I think often the belief is that that person is best suited and that a lot of the requirements from a POPIA perspective relate to IT. That's not the case. I spoke about it earlier around HC being, human capital being impacted, finance being impacted. You should really take the time to find out who is the right person for that role. Who is the person that's got the right skill set, the right knowledge, the right experience and capacity to fill that role adequately, not to do it off the side of their desk, because it is going to have significant implications, as Varsha said, around fines or penalties or administrative sanctions that you could be liable for. So take the time to identify the right person. Think about where that person should sit. Think about how you ensure that person's independence and who they report to. But then also bear in mind that it's not the responsibility of that person to ensure compliance. It is the responsibility of every individual within your organization to ensure compliance. It's the role of an information officer to ensure that you are doing that. So making sure that that culture is through the organization is very important. The last thing I'll say is that whilst there are fines and administrative sanctions attached to POPIA, often we see through our experience in other countries that the actual cost of non-compliance is much bigger than a fine. There are obviously civil claims for people whose information has been lost. And I think a lot of us have seen that in recent months where there's been cyber breaches where personal information has been leaked or lost. And there's also a great sense of loss of trust. And with many organizations, and I think more so as we evolve, reputation is key to your brand. And maintaining the right level of reputation and trust in the people whose information you collect is key. If you get that wrong, whilst the fines and the sanctions will play a role, whilst the civil remedies and payouts that you might have to make from a legal perspective might be significant, rebuilding trust with your individual data subjects is going to take a lot more effort than either of those. So making sure that you have the right compliance and governance and accountability in place is going to be key to the ongoing compliance with the Act. Thank you, Charmaine.
Thank you very much, Karen. And I think even again, when we look at when compliance around COVID started, we all panicked around, but what is a COVID information regulator or COVID compliance officer? Where do we begin? Oh, it's so overwhelming. Oh my goodness, let's shut our offices. But when you train the muscle and you get used to it, I think it's the point you're making that over time, we will settle into the rhythm. And again, I think with partners like yourself, PwC and various other consulting houses, you are there as partners to guide us along the journey as well, which I think is essential.
Absolutely, Charmaine. I mean, we've had a number of clients that have asked us to do the data mapping for them, to look at their gap assessment, to help them get down that road, to say, where do I start and where do I finish? And what am I going to look like on the 1st of July? What is my level going to look like? Yeah.
Okay, perfect. Thank you very much. And again, similarly to BBBE compliance, we also thought that was a big deal, but now we have the processes packed down. So this is just something else that we will get around. Thank you so much to Varsha, and thank you very much, Karen, for your time. We really appreciate it. It's late in the evening, and we know that everybody has a long, exhausted day, but this information is so vital and it's so pertinent. And this is not the last of our conversations. I know that we'll still tap in. And if you have any presentations that you do have available, Karen, please share those with Zintle and with Akida, and they will share with the rest of the members. And Varsha, I'll ensure that both Zintle and Akida actually share your presentation with our IWFSA members who are still online. None of them have dropped off. So clearly this is a topic of importance to them. So thank you very much to our two speakers. We're going to be in touch with both of you as we continue on this journey. And again, thank you so much for your time. We really and truly appreciate it. Thank you very much.
Thank you for the opportunity, Charmaine.
Thank you very much.